Even people who are lawful permanent residents can be put into deportation proceedings, and this usually happens after someone has been convicted of a crime. Today, we want to talk about one way that lawful permanent residents can defend themselves in a deportation proceeding after a criminal conviction. This is not the only way, but it is one very common way that you can defend yourself in a deportation. Just remember that there are two types of something called cancellation of removal. One is for people who are not yet lawful permanent residents, and one is for people who already are lawful permanent residents. Today, we're going to talk about cancellation of removal for people who already are lawful permanent residents. So what are the requirements for cancellation of removal for lawful permanent residents? First, you have to be a lawful permanent resident. Secondly, you have to have been admitted to the United States in some kind of immigration status and admitted lawfully at least 7 years ago. Even if you fell out of that status, you have to be admitted lawfully. For example, if you came to the United States as a student, but later stopped going to school, you will have lost your student status. But if you came 7 years ago lawfully as a student, you could still apply for cancellation of removal because you would have the 7 years in some kind of lawful permanent status. Third, you must have been a lawful permanent resident for 5 years. Some people who get lawful permanent residency through a marriage don't get regular 10-year lawful permanent residency. They get something a little different called a 2-year conditional card. But you can include that 2 years as a conditional resident as part of the 5 years needed as a lawful permanent resident to apply for cancellation of removal. Finally, you cannot have a conviction as an aggravated felon. This is where it's going to start to get complicated. The 5 and 7 year requirements are complicated because you can stop accruing that time needed when you commit a crime or when you're given what's called the notice to appear. And the notice to appear is what puts you into deportation proceedings. Now, if you have committed a crime which makes you inadmissible, you will stop accruing your time. If you have committed a crime which makes you deportable, you will not necessarily have stopped your accruing the time. So the takeaway of the video is this. If you're in deportation because of any kind of criminal arrest, 2 things are absolutely critical. First, that your criminal defense attorney works with an immigration attorney who specializes in the immigration consequences of criminal convictions. There are not a lot of attorneys who specialize in the immigration consequences of criminal convictions, so choose very carefully. Take your time, it's a very important decision. For example, the kind of plea you take or the amount of time you spend in jail could absolutely make the difference between you being deported or you being able to stay in the United States. The second thing that's absolutely critical is you're going to need an immigration attorney who can guide you through the very complicated rules on cancellation of removal for lawful permanent residents. Let me give you one concrete example. Some domestic violence crimes are what we call a crime involving moral turpitude. But if your criminal attorney is able to craft the kind of plea bargain agreement, which would mean it's not a crime involving moral turpitude, you could apply for cancellation of removal. If you're confused, good. Part of my goal is to make sure you understand just how complicated this is and how important it is that you find an attorney who really does understand that intersection between immigration law and criminal law, someone who really understands the immigration consequences of a criminal conviction.